Welcome back to this third segment of this human rights law session. Before the break, we touched on some points, or rather some sections of the Human Rights Act, and certainly we looked in the first segment at some other jurisdictions, and of course the important sections we looked at in the Act were of course sections 2, 3, 4 and 6, and I reminded you not to confuse your section 6 with article 6. Now in this third segment, what I want us to do is to actually go back a little bit in time. I want us to take a little bit of a historical perspective in this third segment. And then I also want to look further on Article 6. So if we go back to the European Convention on Human Rights, from a historical background, we see that the Council of Europe was established in 1949. This was immediately after World War II. Now, the ECHR was drafted by the Council of Europe and it was ratified by certain member states in 1951, coming, of course, into force in 1953. Now, it is established to promote and protect human rights in Europe, especially, as I said before, in light of the dreadful atrocities which had just happened in the war. Now, as a founding member of the Council of Europe, the UK acceded to the European Convention on Human Rights in 1951. However, it was not until about the 1960s that British citizens were actually able to bring claims in the European Court of Human Rights. Now, in the 1980s, it was widely perceived that the executive misuse of particular powers and certainly the lack of any British Bill of Rights meant that there were rights or human rights which appeared by and large to be violated. And there was this need or feel that a British Bill of Rights was needed to secure human rights in a particular framework where you would have a certain degree of human rights culture in the UK. Now, in 1997, there was a white paper entitled Rights Brought Home. Now, this is interesting because you can legitimately get an exam question that said, the Human Rights Act brought rights home. Now, bearing in mind what we discussed in the previous law session, in particular, the actual convention rights which were brought over into UK law, we do see a gap. So, for example, Article 1 wasn't brought over. Article 13 wasn't brought over. It was substituted. Were rights brought home? But nevertheless, what we see with the white paper in 97 is that it said it takes on average 5 years to get an action into the ECTHR once all domestic remedies have been exhausted. And it cost, on average, about £30,000. Now, bringing these rights home, this is what the white paper said, bringing these rights home will mean that the British people will be able to argue for their rights in British courts without this inordinate delay and cost. Now, when the Labour Party won the elections in 1997, one of the points it ran on in its mandate was that it would certainly incorporate the European Convention on Human Rights. So it was a manifesto point for them. So when they won, they sought to fulfill at least one of its manifesto in promising this incorporation. And that, of course, culminated in the Human Rights Act 1998. But this is not strictly true when you look at the incorporation, as when what has occurred is that certain convention rights protected by the European Convention on Human Rights have not become enforceable in UK law. Now, when we look at it, the idea is the European Convention on Human Rights does remain wider in scope than the HRA, and it still remains that if you've got a right, for example, the old point about effective remedy, if you've got a right which is not covered in your national law, you can still take your case to Strasbourg. So, looking at that backdrop then and returning to our roots, as it were, briefly, let's go back to the question, are the convention rights adequately protected for under the Human Rights Act? Now, again, we have seen, as I say, some of the points that the sections of the Human Rights Act have set out. But when you look at the Human Rights Act as a whole, are the rights unlimited? When you look at convention rights, though, we have to consider how they are considered. So, for example, you've got absolute rights and you've got qualified rights. Now, certain convention rights are considered absolute rights. Now, if they're absolute rights, they cannot be restricted in any way or under any circumstances. That's not the same with qualified rights. What are absolute rights? Well, absolute rights, sometimes called non-derogable rights, these are rights which a state must guarantee without exception at all times. And this includes in times of war or other public emergency. So, the kind of rights which are absolute rights, Article 3, prohibition on torture, inhuman or degrading treatment or punishment. So again, go back to some of the issues that have been raised, even for example, in the Iraq War, where we see that there is a zero tolerance as it relates to inhuman and degrading treatment. The idea is Article 3 infringement will not be tolerated. Now this is interesting because whilst the prohibition on inhuman and degrading treatment is an absolute right and will not be tolerated, right to life is not an absolute right. It's a qualified right. So it means it's all right to kill me. It's just not all right to torture me. That's pretty much what you're looking at. And really, that's what your absolute right in Article 3 provides for. Under no circumstances, even in time of war, can you torture or subject me to inhuman or degrading treatment. Now, under Article 4, again, it's an absolute right, prohibition from slavery. Article 7, no punishment without law. Now, again, as I flag up, right to life is not, under Article 2, is not an absolute right because it does fall within the exception that there can be a derogation to the extent that it is permitted in the limited area that deaths resulting from lawful acts of war is, of course, permissible, as it were. It will be interesting, of course, to see, based on this Chilcot inquiry, what this whole framework was in relation to the Iraq War, because the point, of course, is that we see deaths resulting from lawful acts of war. So, if the Iraq War were supposedly illegal, then of course that would have been a breach of Article 2, and that limited circumstances would then have to give way. Now, when you look at Protocol 13, there is no derogation from Protocol 13, which is the abolition of the death penalty. But that said, again, remember there are certain countries who have brought on board the articles or the statements of the articles within their constitution, but they still have the death penalty. Jamaica, for example. The point, of course, being that it has been found that the death penalty is not inconsistent with, for example, a right to life, simply because, again, when you look at Article 2, it does have that derogation in respect of the quality of it. Now, other absolute rights, as I say, all absolute rights, they tend to be non-derogable rights. Now, even when you look at certain other rights, you see that, for example, or certain other articles, Article 5, Article 9, it looks at freedom of thought, conscience. These rights tend to be somewhat absolute. Now, when you look at qualified rights, these are rights where they are subject to, for example, national laws. Article 12 is one such. It is qualified by being subject to national laws governing these rights. So if, for example, the national law prohibited marriage until a person was 21 years old, that would not be a breach of Article 12. So qualified rights would include like Article 12. Now, Article 8, the right to respect for private and family life, is a qualified right because, again, especially in the UK, people tend to draw on this in the context of immigration law. But the point is, your right to respect for private and family life does not mean, for example, that the UK must let your family move to the UK. It just means that, well, or the stance the UK board agency takes at times as well, we are not stopping you from going to live with your family, and so we have not breached Article 8. So it is a qualified right. Article 10, the right to freedom of expression. Now, the right to freedom of expression may have to be balanced. Article 10 rights may have to be balanced against Article 8 rights. So it may very well be that in recent times we have seen, for example, a huge swatch of court cases to do with like footballers, celebrities, who by and large are seeking to stop the media from printing certain things about their private lives. And what they tend to draw on is their Article 8 rights. Now, you have to draw a balance between Article 10, which is a right of freedom of expression, and certainly for the newspapers would be relying on Article 10, and the rights, for example, of these individuals who are saying that they need to draw on their private life. Now, the courts have had to do this balancing exercise, and we see, for example, some of these celebrities looking for these super injunctions and so on. The problem with that, of course, is that what you see developing is a right to privacy, which is not recognized under UK law. So it's trying to use human rights in a way that it was not intended. So this is one of the things that you may very well have to discuss and look at in the context of a question, because the right to private and family life is not the same as a right to privacy. English law does not recognize a right to privacy, but to your private life, yes. So when you look at, for example, the Harry Potter writer J.K. Rowling, we see, for example, people using long lenses camera to, of course, take photographs of her. Even William and Kate, and this whole situation with the French newspaper who had taken photographs of her sunbathing topless or something with long lens camera. The point is, these are Article 8 rights equivalent being contrasted against Article 10. And you tend to find that, if possible, the Article 8 right will win out. But again, I remind you, there is no right to privacy. So when you look at some of these footballers who have been named and then they're seeking to resort to, a right to private life, courts have sometimes said, no, we're not doing that. So the point, of course, is watch your Article 10 versus your Article 8. Now, Article 1 of Protocol 1, right to peaceful enjoyment of property, interference with your property. Please look at the PI and the UK case of that, because it makes it pretty clear how this operates in practice, and it shows you pretty much how you are able to use this. Now, Article 14 looks at an individual's right must be secured without discrimination on grounds of sex, race, color, language, religion, gender, birth, and so on. Now, Article 14 does not create a freestanding right not to be discriminated against, but it is linked to the enjoyment of other convention rights. Now, it is a qualified right to the extent that you may, of course, positively discriminate. So, for example, if there's a reason that you have to discriminate, let's say, for example, you need a situation where you're looking for a house mother in a home where they're all young girls. Well, you may be able to discriminate to say you want a woman, for example, to be the house mother as opposed to a man, because it does or seems to create problems if you start having a man as having oversight of these young girls. So some types of discrimination may be allowed, and by virtue of that, it is not an absolute right, it's qualified. Article 15 permits a state to derogate from the convention in time of war or other emergency threatening the life of the nation. And so when you look at Article 15, it does allow for derogation. The effect of this is that during the period of derogation, the convention right is not protected. Now, derogation was used by the UK government in relation to the Prevention of Terrorism, Temporary Provisions Acts in 1974 to 1989, permitting, of course, the detention of terrorist suspects for up to 7 days without access to a court of law, which would otherwise have been in contravention of Article 5, the right to liberty. And when you look at the case of Brogan and the UK in 1988, we see that this bears this out somewhat. Now, Article 15 has not been incorporated into domestic law either under the HRA. Instead, what you have in the UK is a statutory procedure for derogation, which has been introduced under Section 14. So when you look at rights being brought home, then the two areas that you need to consider are Article 13, which has been replaced by Section 8, and Article 15, which has been replaced by Section 14. Now, that power has been used in 2002 to suspend Article 5 in relation to suspected terrorists, as I said. Now, we're going into the final segment of this human rights law session. When we come back, I want to make some points relating to Article 6 in particular, and then, of course, I want to conclude in relation to the Human Rights Act.